Court does call the case, People versus Matthew Wright.
If you're returning back for people.
I'm sorry? Oh, okay.
Oh, Matthew Wright.
Thank you.
Sorry.
It's all right. What are we doing?
Your Honor, maybe approximately really quickly.
That's how you want to start my day?
Mm-hmm.
Fine. Fine. You're not asking. Jerry says I'm not asking. Yeah, come on. All right. Record to reflect at a bench conference.
Your Honor, this is an exact type of preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of the defendant witness in this matter. And we will be authorizing the case promptly as soon as we can.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is on defendant's motion. Thank you.
And just like that, the case against Matthew Wright is dismissed. Notice how fast that happened. In legal terms, when the prosecution can't produce a witness, the defense can move to dismiss. It's a big reminder. No witness, no case. Have you ever seen justice move this quickly?
Court does call the case, People versus Leon Booker.
Alexander, on behalf of the people, Your Honor.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has. Thank you.
Your Honor, at this time, people are unable to count one. I would ask the court to remand count 2 to district court.
The brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count 1, maintain the plea of not guilty as to count 2. And this matter will be set for pretrial 1482 District Court on
April 30th at 9 a.m. before Judge Barr.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right.
Another case set for pretrial. These moments may sound routine, but for the defendant, this is life-changing. Imagine being told the exact date your fate could be sealed. It's like a countdown clock starting to tick.
Thank you. And we'll continue. Court does call the case, People versus Demetrios Master.
Alexander,
Why are you laughing?
Your Honor, Joseph, on behalf of defendant, state your name. Demetrios Master.
Okay, I got everything but one syllable in there. I was close. All right.
Your Honor, today's the date and time set for preliminary examination. At this time, I would ask the court to amend count 1 to make an attempt interfering with electronic communications. And then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not going to be able to do it that way. I have to, yeah, because what has to happen is count 1 would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm going to need the PAC code on that one.
Here's where it gets tricky. They're amending charges. In plain English, that means the original charge isn't sticking, so they reshape it to something they can prosecute. Think of it like a prosecutor saying, "We can't get you for this, but we can definitely get you for that." Does that sound like a fair tactic to you?
It's likely going to be 755.45A with a bracketed A.
Correct.
Does anyone have any objection to that?
No, Your Honor. Thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that, Judge.
Thank you, Your Honor. Yes.
And court will enter a not guilty plea. Maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshhour, April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right. That would be greatly preferred. It's a DV. She likes to hurry the DV docket, but this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th, 10 a.m. before Judge Freshhour.
Thank you.
Bond will continue. Court does call the case of the People versus Derek Graham.
And is that on behalf of the people, Your Honor?
All two.
During on behalf of the defendant, both matters. Yeah, George.
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, at case 24 FB 1431, the people are unable to proceed as to count one, as that count 2 be remanded to district court. And in case 25 FB 1109, people would ask the court to add count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1. Would ask that count 2 be remanded to district court. Your Honor.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges, count 1 in both files, be dismissed.
All right.
Felony charges dismissed, but hold on. Don't let the word dismissed fool you. New charges are filed, and this defendant is far from free. It's a classic example of the legal seesaw. Relief on one side, heavy weight on the other.
In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed, continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for. Before I give you a date on that, let me.
We're going to ask the court for bond on that matter, Your Honor. So if we can just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking.
Correct, Your Honor.
And the PAC code on that.
750.411H. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation. Good.
I'm sorry, Your Honor. My client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
Sorry?
Miami Avenue in Ipsy.
That would be his home address, Your Honor. I just didn't know whether the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't. Is that that? All right. Okay. All right. So people's response.
Your Honor, we would object to any modification about, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill.
Whoa, did you hear that? The prosecution just laid out chilling threats. Talk of guns, killing children, and daylight violence. These aren't just courtroom words. They're the kind of statements that can lock someone away for years. Question is, will the judge believe these are empty threats or evidence of real danger?
Kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark their ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but did recently on Friday and that she was on board. We have great concerns. And I also believe he has a hold out of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, in regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were
Okay,
from
sorry.
what he sent the victim's phone that led to charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. It was running his mouth, right?
When he's out, is he working? Or
Well, he's been in custody for a while, Your Honor, I assume. So I don't know the answer to that question.
got it?
Charge set up for April 1st, and I said it on this misdemeanor. And they had one that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was going to start April 1st. No, I think they need to go to bond, but she said she wanted something to happen in this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, the only I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
You just want to. My client seems to think that the bonds are $50,000.
10% bid.
Did they get changed at some point?
So the bonds I had originally were both 100,000 cash surety, but were not changed before
He's
the
on
sale.
2 felony cases.
And then he has a misdemeanor case of now he's saying that I believe in 14
So
feet.
he's
Something
reducing.
that he's referring to.
No,
It's 100K cash surety.
Yeah, that's what I have.
That's for the felonies?
On these two cases, I had 100,000 cash surety on each case.
let's work. Jeff.
All right. Thank you. Court, that's called the case of the People versus Haley Gregg.
If you were to look at the people,
Courtroom, please, for assistant public defender on behalf of Ms. Gregg. Ms. Gregg, will you do the podium? Please state your name for the record. Thank you, Judge. Date time set for preliminary examination in this matter. I ask for to Mr. Duffy and Ms. Gray. At this time, the case has been offered to the like this time, second court, for resolution.
Ma'am, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination have been waived. Defendants bound over to circuit court on count 1 with 2 following. Mr. Fisher. Defendant have a waive formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon. Bond will continue.
There's one thing with that.
Oh, go ahead.
My understanding, Mr. Duffy, is that Ms. Gray does not have a full history. Obviously, this case, the allegation is that Ms. Gray is acting out of character for herself. She is ready to take responsibility and resolve this matter, hence the waiver. She is asking the right to consider the reduction of her bond and a possible release. She has no problem with the tether. She would have no problems with the tether and following our court orders. In the meanwhile, I'm going to look into possible treatment courts for Ms. Gray. And she said that she would follow the provisions. I believe she wants to address it directly. I didn't really talk about what happened in this case. Why did you want to talk about? I didn't have why I didn't do like court misstep. I had other issues. Well, I had to chuck was told it, and my phone was in there. I you know, it's not really an excuse, but I didn't really have a way to communicate with anybody, and I was scared. I didn't know what to do. I've never been through this situation. I usually, if I get arrested, I find myself out when I come and I pay my fees. And this has been a terrifying experience. I'm not used to any of this for real. I don't know what else to say other than I'm sorry. If I was going on my character, I wasn't on medication.
So,
Yeah, I've been on my medication. I've been.
okay, let me ask you this. You failed to show, the reason she's in is because she failed to show in February. And I issued the bench warrant. So let me ask you this. What happened after you didn't make that court appearance? What'd you do?
Really nothing. I tried to survive out there. I was homeless. What Jones asked me to do is,
Okay.
why did you not contact the husband of his office or the court? I didn't know what to do. Like I said, I was scared.
Okay, that's what you were talking about. Okay.
Mental health proceedings, like that.
Okay. So let me ask you this. How'd you come back into custody? What happened?
Somebody actually told the police where I was at, and they knew that I had a felony warrant. I guess that they came to the hotel, and I didn't know. I mean, that's how much I don't know. I opened the door. I was like, hi. They're like, hey, I'm like, hey. They're like, yeah, let's go. So I was like, all right. Yeah.
You mean that's how you were talking to the police?
Yeah. We're okay. I mean, I don't, the police, they don't really bother me. They know that, you know, they like me, but they don't. This sounds like that this girl was off the medication. It sounds like she's not on her medication. It sounds like she's been in custody. Something you said, I've been here 21 days, for 21 additional days. She has no problem with the tablet, 100% necessary. She's hoping around to consider release. There's some fact that she's waiting, it's taking some residence responsibility.
Any response from the people?
Your Honor, I don't have any objection to her being released. I'm not sure where the situation is now, where she's going to stay. But given that the location, I think, of the underlying incident was around the Kalana Center, she mentioned she didn't have stable housing. So if there is a tether order, a GPS tracking tether might be appropriate.
Well, I'm not gonna put her on a tether. She has enough problems trying to find housing and put a roof over her head.
I mean, the Kalana Center, I did have, I was there and handled it.
And then you're gonna have to get back on the list to get, I know how it works.
Well, I am, that's why I was so upset with myself. Like, I'm in the house, like the housing list, you know what I'm saying? I don't know how this all works. He knows how it works. And so he understands the difficulties you're gonna have trying to get that into someplace for the sake. I'm gonna stay here. That's not what it said. Oh, oh. I'm terrified right now. I'm shaking.
You're what?
I said, I was terrified. I've never.
You're shaking right now?
No.
Why? Do I make you nervous?
No.
Why do I make you nervous?
It's the high pitch. Yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. I'm like such a kind and gentle soul. I don't know why. Whoa, whoa, Emily, you didn't have to have that response. Wow, wow. Wow. Alan, you could have stuck up for me. You could have. No. Wow. Everybody's just turned on me. All right. Miss Gregg, here's what I'm going to.
And there it is, bond reduced, defendant walking out today. From trembling with fear to getting an unexpected second chance. Courtrooms are unpredictable. Sometimes the law comes down like a hammer. Other times it opens a door. What would you have decided in her case?
I'm going to reduce your bond. All right, in this case, I'm going to reinstate it back to what it was, to a $15,000 personal recognizance bond. Now, in doing that, Ms. Gregg, you got to make sure your next date is the 7th. You make sure you get there. You hear me?
Yes, sir. Yes, Your Honor.
Okay.
That face.
You didn't even think that would happen, did you? Okay, you get out today. You're welcome. Take care of yourself. Wow. She did better than you. Alan wasn't going to do anything. He just, see, Alan, he's so hard. Wow.